May I now request our guest of honor, Shri Aman Lekhi ji, Senior Advocate, Supreme Court of India, to kindly interact with the students on this topic of Constitution.
Professor Khanna, Dr. Dogra, Mr. Singh, Professor MP Singh, Mr. Chaturvedi, Justice Gupta, and Professor Gupta. I'll depart from what I had actually prepared myself to speak because a very thought-provoking address which has come from Mr. Singh. While I'm sensitive to his feelings, which are very profoundly expressed and very strongly held, I think I will disagree altogether with the dismal note about the Constitution of India which is sought to be sounded, and the suggestion which is sought to be provided that this requires an overhaul. And I personally think that the fundamental flaw in this particular approach was the concentration on the British system, ignoring the fact that as far as our Constitution is concerned, our Constitution does not draw from one source only. Insofar as the Constitution is concerned, it does draw from Britain. But is it the only country from which it draws? It draws from diverse countries, from the United States to Canada to Australia to Germany to South Africa. All the different countries, various systems, all of which were examined and were scrutinized to eventually decide what is it that the Constitution would be. And insofar as this submission is concerned, what it ignores is the basic fallacy that's called the Modoc fallacy. Now, the Modoc fallacy is you look at the constituents, but you don't see the arrangement. The Constitution, when you see the Constitution as a totality. You don't pick up individual provisions of it. You don't deal with particular aspects of it. You see it holistically and comprehensively because, and I'll come to this later, it's an organic document. An organic document is very important. What is a constitution? Because that's not what was dealt with. It's an organic document which is the foundation of governance. And a document which is the foundation of governance, as Mr. Singh very correctly said, should be in harmony and in sync with the general understanding of law. And as far as Indians generally are concerned and India is concerned, as is apparent from the different trajectories which two nations took, though both became independent the same year, as far as India is concerned, India is a mature democracy. It is inherently a mature democracy because, it may sound communal, because of the majority population over here, which population itself is not aggressive nor communally inclined. So the principles of the preamble which are referred to are actually ingrained in every Indian. And when those are ingrained in Indians, and it is Indians who have to work the system, whatever system will be put in place will work as the Indian system has worked. And there is no point in saying or being in any way dejected about it, because I very strongly feel very optimistic about our system, and I don't feel there's anything amiss in it as to require review. What Mr. Singh said was the panchayats, very well. It was not there in the Constitution originally enacted, but was there not the 73rd Amendment? Did it not bring in the Constitution something which is not there? That means, does the Constitution does not have a provision to incorporate something which may not have been there, but which the circumstances require, the need of the situation warrants. So the Constitution itself provides for such contingencies and makes provision for it to bring in that which may not be there. The second example, and a very pertinent example, which Mr. Singh gave, was about Article 25. Yes, where Article 25 is concerned, and I completely share his concern, that as far as the orientation was concerned, the orientation was in some way Western. Because as far as Nehru was concerned, Nehru was insulated from India, Nehru disowned India. Nehru was more British than any Britisher would be. I completely agree with that is concerned, but fortunately we have moved on. We had developed our own jurisprudence and we had developed our own norms, and that is where, which we'll deal with it in a minute's time, a constitution is not merely the text. The constitution is also in its conventions, and conventions are the non-codified aspects of law. And the non-codified aspects of law control and regulate the exercise of power. And whatever may be the excesses or problems of the Constitution are corrected and in some way controlled and are reined in by conventions. And we have healthy conventions here which protect constitutionalism. So you can't look only at the text when you talk about the Constitution. When you talk about the Constitution, you have to look at the text and the conventions. And as far as the conventions are concerned, yes, there are aberrations. Yes, there are problems. There are issues. But there are issues in any system which will be brought into place. You replace the system with another system, the people working the system will be the same. And the tendency we have over here in bringing in more laws, bringing about amendments to laws, bringing about repeal of laws, would ignore the basic thing. We have enough law already. The principles are in place. The foundation is laid. It has to be worked, and it has to be worked intelligently. And I personally think this Constitution can actually so work. So it is very necessary to know what is the Constitution. What a Constitution is usually, and generally, unlike the British experience, which has a series of constitutional documents but not a single constitution, it's an organic instrument which confers and circumscribes powers, whatever the system may be. So they have a fundamental document which grants power and limits power. Whatever the system may be, the point is this is a constitution, while granting powers, circumscribes powers. So it, in some way, in a very emphatic way, makes law the foundation of a society. And why should law be the foundation of society? Because no edifice, no matter how grand, can ever survive unless its foundations run deep. And the foundations of India run deep because of its constitution. Compare it with, I'll give two examples. One is a recent example of the US elections. The other is a perennial and perpetual example of our immediate neighbor. What did Pakistan do? 1947, both started the journey. What happened? 3 constitutions. They had a constitution in 56, which they abrogated in 58. Then they got a constitution in 62, which they suspended in 69. Then they got a constitution in 73, which they suspended from 79 to 85. Then they brought in amendments, etc. Insofar as the amendments were concerned, to in some way deal with it. Why this perpetual change in the constitution? Because there is no stability in thinking and no norms of the moral fiber for restrain the exercise of power. It's easy to change. It's easy to repeal. But it's difficult to work. Because working requires an application of mind and understanding of what is being created. India has worked its constitution. And India has worked its constitution well. So that in an area which doesn't in any way, look at Nepal. Nepal doesn't have much to speak for itself where constitutionalism is concerned too. That is immediate neighbor. Pakistan, Bangladesh, in a mess. Sri Lanka, with the problem which Sri Lanka faced. Why is it? Why is it that India is not in that condition? Yes, the credit goes to Indians. The majority of Indians, the credit goes. But it goes to the Indians because of the constitution which we have, which constitution in this particular way controls, manages, and helps us govern this country. So when we talked about these issues, what was actually said by Justice Khanna, and this is very pertinent, Constitution is a question of statecraft. It will harmonize 2 things. 1, the practical needs, and 2, the ideals. Our Constitution embodies all the ideals. Name anything which is mandatory for good governance, it is there in the Constitution. Can a Constitution provide for more? A Constitution is not a self-operative document. All a Constitution can say is provide a benchmark to guide action and guide us as to how we have to proceed further. Is the Constitution lacking in any of those aspects? No. Because what are the ideals which have to animate us for us to move forward? All of them are incorporated in the Constitution. They are part of the constitutional mandate. So much so that insofar as Part 3 is concerned, which reference was made, is not only rights, it's got declarations also. Declarations against exploitation, declarations against abolition of titles. The right also to profess and practice religion. And yes, propagation is a problem. But that problem can be dealt with legally. Because there have been laws which have been enacted by states barring conversion. The problem with Article 25 is not a question of propagation because you deal with the issue incorrectly. The problem with the law is the claim that Article 25 gives the right to convert. Article 25 does not give the right to convert. And though Mr. Sirvai had written a complete chapter justifying this, and that's the way the system works. I had written a criticism of Mr. Sirvai's chapter, in which they had he had dealt with this issue of right to conversion, pointing out that on Mr. Sirvai's own reasoning, that particular chapter is wrong. There is no right to convert. I sent it to SCC, that is their journal section, and that is many years ago. And I told them, please publish it. They chose not to publish it. They chose not to publish it because it was contrary to the given understanding that yes, there are few persons who are not to be criticized, and there are few topics which are not to be touched. The problem in any system is not the physical framework of the system. The problem in every system is the character of those who work it. And this example which I am giving on a macro level will be a problem in a country. Whatever may the system be, until we identify what is wrong and are man enough to correct it and have the courage of conviction to stand by what we say, and also the honesty to concede where we are wrong, that yes, we committed a mistake, no system can ever succeed, whatever system may be put in place. Now, Mr. Singh said parliamentary system is unsuited. What is the system in its place then? What is a presidential system? A presidential system doesn't have problems. The spoiled system is one of the biggest problems of the presidential system. That the gridlock between the legislature and the executive is a problem of the presidential system too. And though I am not in favor of it in the current scenario, I am sure our prime minister would have been happy as a president rather than a prime minister. But in a particular situation, we can have the wrong people too as presidents. And that is the reason why during the emergency, an attempt was sought to be made to substitute the system with a presidential system. Why? Because that is a means to aggrandize power. That is an ideology which is sought to be used. But that's not necessarily an ideology which is appropriate. And it's not as if what has been done was not done earlier. We had a review of the Constitution. We had a committee examining the Constitution. And if you have read the report of that review, what you would find is there is no major change suggested. And what the review committee actually says is incorporating that which is judicially recognized and judicially enforced and putting them in black and white in the Constitution itself. So when a committee is constituted to review, and the committee on constituting the review does not suggest an overhaul, I do not think it is appropriate at this juncture of our evolution, where we have become used to our Constitution, to basically say that no, it's time to change. Because why? There's a reason behind it. We are in a very difficult political condition. We are in a very precarious geographical position. We are in a country where there are vociferous tendencies which are within the country. At this point of time, we need stability, we need coherence, and we need community of interest. At this point of time, the Constitution, which is the foundation of our country, on which we rely for the purposes of governing ourselves, with which we become used to. If we do away with that Constitution, then nothing but chaos will follow. Because that single grand norm, that principle, if you call the role of recognition, whether it's the positivist, or we talk about principle talking Dawkins, that will no longer cease to exist. And the unity of normative constitutionalism, which is in fact holding our country together, will vanish. So I am not in favor at all of actually deriding the Constitution, undermining it, or criticizing it. There are flaws in it, but there's a method to correct the flaws. What are the methods to correct the flaws? Now, Mr. Singh referred to federalism. What is the peculiarity of federalism? You will not find a federal structure like India's. Because again, it's a combination of various aspects. It takes from the USA, it takes from Canada, it takes from Australia, it takes from various to make a federation which is distinctively Indian. It is not a federation which you will find everywhere. And the federation is suited. Why? Because it's been condemned as unitary. It can be called cooperative, that is better. But it's a federation which is suited for the country because it leans in favor of the center. There's nothing wrong with the federal government. Now we have, insofar as the states are concerned, plenary powers. The states are plenary in their field. But though the states may be plenary in the field, there are limitations on what the state can do too. And insofar as interests of national concern are concerned, they are all in part 1 of the 7th schedule of the Constitution. That means the local interests, the state interests, can be dealt with by the states, but as the issues of national concern will be dealt with by the centre. And that is what was dealt with the recent judgment of the Supreme Court, the entry tax, in which they conceded that yes, the right to impose entry tax cannot be struck down. Why? On this understanding of our federal system. That's the reason why this particular system happened. Then so far as judicial review is concerned, we have taken judicial review too. Now judicial review is not British. Judicial review is American. Now if judicial review is American, that means you can strike it down. Had it been a British system, it would have Parliament would have been supreme. And if Parliament is supreme, there's no question of review. But we brought in review, why? Because we can strike it down. But this is not the only way we can change the Constitution. We have a procedure for amendment. That means apart from the court intervening to strike it down, we can amend the Constitution too. But you can't amend the Constitution and change the basic structure. From where does the basic structure come? Basic structure is an indigenous growth. That means the fundamentals of a polity, not the text, not the parliamentary system. The parliamentary system, yes, democracy, federalism, secularism, the freedom of thought, they are basic because you can make changes in the Constitution, but you cannot make changes of the Constitution. So the Constitution cannot be changed. So we have methods to change, but we got a sanity to the change too. And they got a method to this particular exercise. That's the reason why I mentioned the 73rd Amendment to the Constitution, which brought in the very thing which was not there when the Constitution was enacted. Which, and while I've taken too much of your time, the last aspect I want to deal with, because I go back to the Constituent Assembly for that, the expression "we the people." It is not just a philosophical expression. It's not just borrowed from the Americans. There's a reason for it. And reason in the Indian Independence Act. And that's very peculiar. The Indian Independence Act has Section 6. Now, under Section 6, the Dominion legislatures at that point of time were rendered plenary. But what Section 6 stated also was that the creature under the Act was not bound by that Act. That is 6(2) of the Indian Independence Act said that. That means the most novel thing, that which is created by the statute which forms it, is no longer bound by the parent statute. Which is the reason why when we made the Constitution was not submitted to the Governor General. And we adopted the Constitution. And we adopted the Constitution and we gave to ourselves the Constitution. So that is a very naturalistic thing to do. And while Nehru had an important role, Ambedkar had an important role, Rao had an important role, don't discount the members of the Constituent Assembly. As many as 7,500 amendments were moved, of which more than 2,500 were accepted. And after changes were made, it was put for 8 months to the country for the purposes of getting inputs as to how the country, whatever changes have to be made. And it was then that the Constitution was adopted. So let's understand what the Constitution is. Let's appreciate its worth. Let's work it intelligently. And yes, while acknowledging that there may be something wrong in it, change it as the Constitution warrants. Not because what an ideology seeks or our personal subjective opinion justifies. Thank you.